The Supreme Court of Canada was founded in 1875. Since its creation 150 years ago, its essential task to make independent and impartial decisions about issues that matter to Canadians, a responsibility that remains paramount today. Former Prime Minister and Justice Minister Kim Campbell.
Its judgments provide the architecture of the law for all other courts in the country, but its role in Canada has changed over the years as our constitutionality has grown. And perhaps, as I say, the biggest impulse for that, the biggest catalyst for that, was the patriation of the Constitution with the Charter of Rights and Freedoms.
It's regulating with the heaviest instrument the law can apply.
Former Chief Justice of the Supreme Court, Beverly McLaughlin, joined the court in 1989 and was appointed Chief Justice on January 7, 2000, a role she held until December 2017. During her 28 years on the bench, a number of historic charter cases were decided.
This new set of rights that citizens possessed and could take to court changed the role of all the courts, and particularly the Supreme Court of Canada, where most of these difficult questions ended up.
The Constitution is now home.
The Charter of Rights and Freedoms, proclaimed into force on April 17, 1982, reshaped the role of the court. Essentially, the Supreme Court could now review and strike down legislation that violates rights and freedoms. Bora Laskin was the first Jewish Chief Justice. He presided over the court for the first 2 years of the Charter. He died March 26, 1984, and Brian Dixon became Chief Justice later that year on April 18. Former Justice of the Supreme Court, Frank Iacobucci.
I applaud the Dixon Court, Chief Justice Dixon, and his colleagues who had to deal with that first slice of cases that came to the court to give it a framework for dealing with rights and violations. You don't want, you want the Charter to mean something, to be significant in the lives of Canadians. But at the same time, you don't want to substitute the role of a legislature or parliament in making that interpretation in a particular case. So that was challenging for everyone, including the court.
Good morning, please be seated.
The High Court's job is to make legal decisions generally considered of high public importance.
For all the native people of Canada.
Author and political science professor at the University of Toronto, Robert Schertzer.
It has a role that's somewhat like a parent. That, when parties are disagreeing or have a significant conflict, someone has to render a decision. And so that's largely what our Supreme Court does in our system of government.
The underlying freedom of liberty of movement actually does apply to both.
The Supreme Court serves as both a constitutional court and a Supreme Court, and is unlike any other high court around the world. One of its most important powers is judicial review. Adam Dodek is a law professor and former law clerk and author of numerous books, including the Canadian Constitution.
Judicial review is the function of the court in either reviewing executive action, actions by the government at whatever level, or when we talk about constitutional judicial review, we're talking about the court reviewing legislation of either a province or the Parliament of Canada to see if it accords with the Constitution of Canada, and if it doesn't, then the court can declare that legislation to be unconstitutional, or in sort of everyday terms, to strike it down as invalid or inconsistent with the Constitution.
De ce qui a été pris en considération avant.
It is the only bilingual and bijural Supreme Court in the world. It hears cases from both common law, which originated in the Middle Ages in the English King's Court, and the civil law, which traces its origins back to ancient Roman law. Quebec's legal system is based on civil law, The rest of Canada is based on common law.
It was refreshing, I thought, to have the two systems working together in a way that one learned from the other systems. But it all towards what is the function of law? Justice. That's the goal of law.
The court hears appeals from both provincial and federal courts. These appeals can be an appeal with leave, which means an appellate court has granted permission to go to the Supreme Court. It can be as an appeal as a legal right, or the court can hear a reference case. These cases come from either a provincial or federal government to provide an advisory opinion on a legal issue.
That case proceeds through several months of preparation when counsel prepare their briefs called factums, and there's also a possibility for third parties who are interested in these questions of national importance that come before the court to apply to intervene so they can bring different perspectives.
While the courts don't make their decisions based on, what's the public opinion, their understanding of the true resonance of rights grows with experience. The rest of the country is taking its lead from the decisions of the court. And as I say, that whole architecture of the legal system, all the lower levels of court that use the Supreme Court decisions as their guiding, lawyers understanding, should I take a case, should I not take a case? Minister of Justice saying to their colleagues, I don't think this is going to withstand charter challenge because in this decision the court has made this point. So clarity is so important.
The court is one of three distinct branches that make up the democratic system: the legislative branch, the executive branch, and the judicial branch. And as the role of the court has evolved since it was created 150 years ago, some legal experts argue the court is political. Christopher Manfredi serves as provost and executive vice president at McGill University.
I think the Canadian Supreme Court, like all final courts of appeal, is a political institution. It's not a legal institution. It makes policy not as an accidental byproduct of performing its legal function, but because collectively the justices decide that a particular legal rule, and this is especially true in charter cases, a particular legal rule will produce a more socially advantageous set of outcomes than alternative rules.
Others argue the court still has a lot of work to do to gain the trust of specific communities in Canada, including Indigenous people. Naomi Metalik is a member of the Listigouche Mi'kmaq First Nation. A former Supreme Court law clerk, lawyer, and a professor at Dalhousie University, she argues for generations the Supreme Court upheld laws that were used as tools of oppression and repression against Indigenous people.
In terms of, representation and legitimacy of the court, and the court has a real checkered history on Indigenous issues. That's a big reason that Indigenous people question the legitimacy of the court. So having people representative of Indigenous peoples, as well as having the court be more mindful of Indigenous issues, can be, things that will increase the legitimacy of the court in the eyes of Indigenous populations and other populations where they are represented.
The law is an idea. So the justices have to express that idea clearly in order for people to really follow and understand. If you can't follow the rationale of why a decision's made, what is the legitimacy to make it? They're not elected, right? So they have to ensure that they're following and clearly articulating the law.
The right of appeal, it is a statutory right.
Transparency in decision-making is important for the Supreme Court, and so too is ensuring the court is viewed as a legal institution and not a political one.
I, Michael J. Moldaver, do solemnly and sincerely promise and swear.
Michael Moldaver served on the Supreme Court from 2011 to 2022.
I just want to make it perfectly clear that that way of thinking of any court, but particularly the Supreme Court of Canada, as a 9-person parliamentary committee, is not only wrong, it's dangerous. The court doesn't have the resources, the wherewithal, and most importantly, the constitutional authority to start mixing in on matters that the Constitution has entrusted to the other branches of government, namely the executive branch and the legislative branch. As a cautionary matter, I want to make it very clear that it's vital that the three branches of government, judiciary, executive, and legislative, stay within their own lanes. Because if they start going outside their lanes, in my respectful view, that's the beginning of the end of a constitutional democracy.
Coming up in our next episodes, we bring you more on the inner workings of the court.
The court needs as much as possible consensus because the consensus gives clarity. The rest of the country is taking its lead from the decisions of the court.
The critical importance of judicial independence.
Courts have to be impartial, and for that reason they have to be completely independent of these other branches of government and seen to be independent.
And we look back at its history. All that on the next installments of CPAC's Inside the Supreme Court of Canada, 150 years of the highest court in the land.